versus Hacker King Sherry Agency, docket number 17-768CK. This is consolidated with Pioneer State Mutual Insurance Company versus Holder, which was docket number 17-836CK. And this afternoon we have Hacker King Sherry Agency's motion to place the trial in the Pioneer case before the trial in the Holder versus Hacker King Sherry case. And if I could first have your appearances for the record, please.
Frank Fleischman for the defendant Hacker King Sherry Agency, Your Honor.
Nave on behalf of Pioneer State Mutual Insurance Company.
Kevin Combe on behalf of Todd Holder, Your Honor.
Okay, and this is your motion, Mr. Fleischman. Go ahead.
Yes, Your Honor. To be brief, I have nothing much more to add than what was in our motion. I believe that judicial economy would require that the Pioneer Mutual case go first.
Okay, and Mr. Nave?
Your Honor, just looking at the motion, I don't know that there's a compelling reason stated to change the current order that we've been operating under. In terms of just looking at the case, and Your Honor is well familiar with the various issues going back and forth, having heard the cross motions for summary disposition. Hacker is not a party to the Pioneer suit, so even in the event that Pioneer were to go first, many of the issues would have to be relitigated again in the Holder versus Hacker action. And so it's our position that with respect to judicial efficiency, that it would actually be more efficient to have the Holder versus Hacker trial first. And we've stated that in our brief as well.
Well, let me ask you this. If many of the issues are the same, and I think they are, especially the factual issues, which I think would mostly center around that conversation where Sharon Holder obtains the coverage for the Chevy truck, I think it is, why wouldn't they be consolidated for trial?
I think one of the issues is that in terms of the declaratory action, and I can't speak as to the other action, we're seeking equitable relief, so that would definitely be something for Your Honor. And I have to say that with respect to the Holder versus Hacker issue, I'm not sure if there is a jury that's been requested in that case, so that would be one issue that I would see as potential. But the other counsel for Mr. Holder and Hacker could address that in terms of, whether or not there is a jury issue that has been for which they've requested a jury trial.
I'm 99%
I believe you are correct, Your Honor. There is a jury requested. However, I also do not see much reason why these cases can't be consolidated. You can rule from the bench and the jury can rule on its own.
Yeah, because it seems like it's the same facts.
Exactly.
Very similar, Your Honor.
We're all nodding our heads. Are we all agreeing?
Yes, Your Honor.
I agree, Your Honor. I don't want to have to try the case twice. I'd rather have all the witnesses there at the same time. In just my cases against Pioneer, my cases, stripped to its bare bone minimums, it's just a PIP case. They say there's fraud. I say you owe PIP benefits. There's no fraud. And then on the flip side, if the jury says, yeah, Holder doesn't get any benefits from Pioneer, then I've got my claim, my E&O claim against Hacker. And it's all the same witnesses that are going to have to be involved in both trials. So the Hacker witnesses are going to have to be involved in the PIP case, and the PIP adjuster is going to have to be involved in the Hacker case. So,
well, the only thing now that I've suggested it, and the Pioneer case, though, they're seeking rescission, so that's not a jury issue. So what if we did them both together and then I disagreed with the jury? Because the two are mutually exclusive. I mean, either
is there a way that you that the jury does not know that you have the ability to make that decision, that you hear the proofs, and that if you look at those things and you say, hey, I agree with Pioneer, and then the jury's just dismissed and all they know is that the case is over. They don't know the resolution. They don't know what happened. I mean, occasionally it does happen where there's a directed verdict and cases settle and juries don't even know what happened.
Right, but it would be a factual determination. So I can't direct a verdict. I'd deny the holders their right. If that happened, I would deny the holders their right to a jury trial because I could only do it based on disputed facts, not as a directed verdict. You follow me?
Yeah, and I brought up directed verdict just as an example as to how the impact would be on a jury. So if you made a decision prior to the case even getting to the jury, it would have the same impact on a jury as if there was a directed verdict. And it happened. We've all seen it happen where a jury doesn't make a decision. So I think we can consolidate and have you make any decision prior to the jury making any decision. And if you rule
on the
against
rescission,
the jury doesn't have to make any decision at all.
Your Honor, just in terms of
then we go to the Pioneer, or excuse me, not the Pioneer. Then we go to the Holder versus Hacker King Sherry issue, and we just tell the jury, your only decision is with regard to the E&O claim, and that's it.
Okay, was it the holders who asked for the jury trial, or was it Hacker King Sherry?
I'm going to take a peek.
I believe holders asked for it, and we filed a reliance upon that.
Okay. I never ever suggest this because I think it's, borderline improper. But if Mr. Komar is proposing that on behalf of the holders, then you could also waive jury and just do it all as a bench trial. But again, I'm only throwing that out there as an idea because of the unique situation that we have here. And that is entirely up to you. But I think at this point, although we may not have every logistic down, I think everyone's in agreement that these could be consolidated.
Your Honor, I think they could. There would be some logistical things in terms of representing Pioneer and standing in front of the jury and not really in the normal situation paying attention to the jury. I mean, you try a case differently if I'm trying it to the court as opposed to the jury. There might be that. One other thing I just wanted to bring up in full disclosure as well. We have been kind of sitting on the sideline, and Your Honor heard the cross motions for summary disposition, and because of the order of the trial, we had not renewed our motion for summary disposition, which we would like to do at this point in time. At one point, we had filed it, it went to hearing, and I think at that time, Your Honor, because I'm coming into the case late due to Ed Davison's retirement, my recollection is that the Bozzi opinion may have been pending at that point. So that might be something as well. We would like to renew that motion, and I could file something fairly quickly within the next couple of weeks, so that comes before Your Honor.
Well, then maybe what we need to do is sort of put this issue on hold with a tentative resolution of consolidation and allow you then to refile your summary disposition and go from there.
That would be acceptable.
That's acceptable to us, Your Honor.
Mr. Komar?
Well, I don't want to start arguing the summary disposition motion.
No.
But I mean, Bozzi is what Bozzi is, Your Honor, and that's what, and you know where I'm going to rely on. And I think that was the reason why the court initially, did we get a denial order? Or was the motion just withdrawn?
I believe at that point, I don't know procedurally, I think it was withdrawn at that point, or it was just kind of put on hold. I haven't seen anything one way or the other in the file.
I don't remember.
I can open up mine if will let me go into my system right now. But if I remember right, Bozzi came out in May of 2018. I'm going to go through and see just real quick, and maybe I can even share it through my screen. if I can find it.
You just want to show off your Zoom proficiency?
I don't
Hey,
want
I
to show
got
it
audio
off because
this
I'm
time. I mean,
afraid
come on.
what I'm afraid I'm going to do is lose everybody. Your Honor, there are so many pleadings in this, I could spend the next 15 minutes keeping everybody on hold.
Okay, that's all right.
But what I will do is, if there is an order that was already entered by the court, is I will, is that it? Nope, that's not it. What I will do is I will circulate that to defense counsel if I can find it, because I know Greg was not on the file. Ed Davison was arguing it initially, and then this case has gone on for so long that I made Ed retire. So.
Okay, so I guess we can leave it at that, right?
That sounds good, Your Honor.
And what I'll do is, if there is an order, part of my response will be I object to the hearing because this court has already entered an order based upon Bozzi. Again, I can't remember procedurally what that was because it was 2 years ago now.
Yeah. Okay, then I guess that's where we leave it.
Very well, Your Honor.
Okay.
And I'll work to get that motion filed ASAP.
All right.
Thank you, Judge.
Thank you, Your Honor.
Thank you, all of you, and that will end our hearing.
Thank you.
Thank you.